Today, the Supreme Court begins its fall term. Outside of law, these are highly partisan issues. Second Amendment rights, school choice rights, unfortunately, has become highly partisan. And, of course, the debate over abortion. The big case, the one that's going to get the most attention, the idea here, Thea, this is the justification for their idea of court packing or rearranging the court is the Dobbs case out of Mississippi, and the fact that so much attention on these cases involving abortion, but this is a major one because it's a direct challenge to Roe versus Wade. So it's not just like a partial birth abortion ban. This is a 15-week ban. It's the most serious abortion case the court has taken in decades.
This Dobbs case, Jordan, it was interesting when the various sides were filing their briefs in the case. Planned Parenthood and NARAL essentially said, well, you can't side with Mississippi on this because that would be a change to the fundamentals of Roe and Casey. That would challenge the actual merits of Roe and Casey. Surely that can't be what Mississippi is asking for. Mississippi came right back on top and said, yep, you got exactly right. We think Roe and Casey were wrongly decided. We are enacting our state sovereignty to restrict abortion before the accepted stage of viability that was set in Roe. Clearly, that is not any longer in step with medical developments, and we're going to challenge it.
There is a perfect storm brewing at the United States Supreme Court. This perfect storm puts Roe v. Wade in the crosshairs of Supreme Court jurisprudence, and I think this particular challenge to Roe v. Wade has a reasonable chance of succeeding on the merits.
Then another school choice case. We thought after the Espinoza case, where the Supreme Court basically struck down those Blaine amendments that were really anti-Catholic amendments back in the day that states adopted, the federal government never adopted. The court is looking at one of those again. So this is yet another opportunity to open the door for more school choice options, including religious schools. So the challenge there is specific to it's a religious liberty case.
One wonders why the First Circuit Court of Appeals actually upheld the particular main statute which is at issue. At the end of the day, the right to send your kid to school in a non-discriminatory basis is arguably a right that the Supreme Court has already upheld. And so I think at the end of the day, it's highly doubtful that this main statutory provision, which prevents parents from sending their kids to a sectarian school, will indeed be upheld.
If you base off their precedent, the existing precedent, it's good for the school choice. It's good also because if you're a school choice advocate, if you're someone that supports school choice, clearing these laws, making it clear that school choice is legal in a state, and that if you're going to open up the opportunity for people to have the choice, that you can't exclude a group of schools from a parent's decision. Remember, no one's forcing you to send your kid to a Catholic school or religious school in these states if you were eligible for the school choice program. It's just saying if you're eligible, these schools, if they want to be part of this program, have the right to be in the program. The New York case is New York Rifle and Pistol Association versus Corlett. This is a case out of the Supreme Court. The New York law says that so to get your concealed carry permit outside the home, you have to show proper cause. So you have to have special need for self-protection. Now here's where that goes. That favors the elites, right? That favors celebrities, the wealthy, not the average person. That's not how the Second Amendment reads. It's not a right if you can show cause. So right off the bat, I think that this law is in serious jeopardy.
You can't really look at any of the amendments in our Constitution, the Bill of Rights, and say, well, they only apply to you if you're special in some way, or you have to show proper cause, while you have protections under an amendment to the Constitution. And that's really what this New York law is saying, that in order for the Second Amendment to apply to you, it doesn't apply to you because you're an American, because we have a Constitution, but only if you can show proper cause why you need it.
It's just one of those classic examples that if one of our First Amendment rights, Second Amendment rights, Bill of Rights is, well, you get this right if you can show us that you need it. I mean, it's classic political move.
The Second Amendment guarantees an individual right to bear arms. It's not a right that the government grants. And if there's going to be any restriction or any limitation on that, where does the burden lie, Jordan? The burden has to lie on the federal government. It can't lie on the individual who has to prove, as you were just saying, that they are entitled to this right. Jordan, they start with that right, and any restriction on it, any burden to limit that in any way has to fall on the federal government.
I feel like there's similarities there between these cases about how you view the Constitution.